Hello, and welcome to today's Hotel Investor Marketplace webcast produced by Hotel Brokers International. My name is Jennifer Church, and I'm currently president of Hotel Brokers International and president of Millmark Hotel Motel Investments, LLC. We're pleased to have you with us today for attorney Andria Ryan's presentation on employment law, the top challenges facing the lodging industry today. While everyone's continuing to join us for today's webcast, I will just share some brief information about Hotel Brokers International and about today's webinar for you. First of all, a little information about Hotel Brokers International. Many of you know us as HBI. Founded in 1959, HBI is the leading network of real estate brokers specializing exclusively in hotel investments. We provide assistance with every phase of the hotel brokerage process, from hotel evaluations to closings. You can visit HBI on the web at hbihotels.com. Now, for some information about today's webinar for you. To ask a question during the webinar, just type your question under the Ask a Question box below the webcast player. We will answer as many questions as time allows. We also have included some attachments and links, which can be found under the Attachments button. The attachments will be available during the webinar as well as later today when the recorded event is posted on our website for on-demand viewing at hbihotels.com. We would like your feedback on today's webinar. We hope at the end of the webinar you will take just a moment to let us know how you enjoyed it. You can do this under the Rate This button at the bottom of the webcast player. Finally, the Details button allows you to share the webcast via your social media accounts with others. We invite you to do that. At this time, I'd like to welcome our speaker. Andria Ryan is a partner in the Atlanta office of Fisher & Phillips, LLP, and she serves as the chair of the firm's Hospitality Industry Practice Group. Ms. Ryan joined the law firm in 1988. She received her bachelor's degree from American University in Washington, D.C., and received her law degree from Catholic University. She represents numerous hotel, restaurant, resort, and related employers throughout the United States in various phases of labor and employment law. She spends much of her time counseling employers in day-to-day employment and labor decisions and educating employers about prevention and practical solutions to workplace problems. In 2005, Ms. Ryan served as chair of the State Bar of Georgia's Labor and Employment Law section. She is a guest lecturer on employment law topics at multiple universities. Ms. Ryan serves as an active member on the American Hotel and Lodging Association's Human Resource Committee, the Resort Employee Relations Group, Hospitality Lawyer, and the Advisory Board of Hospitality Law. She is the author of the Hospitality Industry Employment Law Q&A for Lexis Practice Advisor. Also, she has been honored by the Colorado, South Carolina, and Washington Hospitality Associations for her contributions to those organizations. We are thrilled to have Ms. Ryan with us today, and I'm happy to turn things over to her now.
Thank you so much, Jennifer, for that very kind introduction. And hello, everyone. Good morning or good afternoon, whenever you're watching us. Nice to have you. I get to talk about some interesting topics today, and we're going to jump from several of them because we titled this The Top Challenges Facing the Lodging Industry Today in Employment Law. And so we're going to go from sexual harassment to some wage and hour, transgender employees, sick leave, criminal background checks, so a little bit of everything today. But I'm going to start with what seems to be on everyone's mind. I recently told a colleague I do a lot of public speaking, and I have almost 95% of what I've done in the last 6 months has been talking about #MeToo and the sexual and the problem with sexual harassment, especially in this industry. So we're going to start with that. We're going to start with #MeToo and the publicity surrounding it. As you know, and I know I'm not telling anything you haven't seen yourself, the publicity surrounding the Harvey Weinstein and then multiple other complaints has just revealed organizational cultures in a number of industries that just seem to permit or allow systemic and pervasive harassment, and no industry is immune from this. I work in a law firm, and law firms, we read in the legal rags about law firms that are being sued for this. The problem is, or I guess not a problem, is that we don't get national attention like other industries seem to get, and so maybe we're thankful for that. But it's everywhere. It's in healthcare, it's in the legal field, it's in accounting. As you turn on the television, I can't turn on the nightly news anymore and figure out who's left because we've got so many folks in that industry. And the hotel industry is not immune either, the lodging industry and the restaurant industry. As you know, we've seen many chefs nationwide who have been accused of significant misconduct, and some hoteliers as well. And so it's really time to sort of dust off your policies and procedures when it comes to harassment. I told an audience recently, I was doing some training with some leaders in an organization. I said, you have a really good harassment policy. I said, in fact, I wrote it. I wrote it several years ago. I think it's an awesome policy. But when was the last time you actually looked at it and paid attention to it as leaders in your organization? And so I think the mere act of sort of taking out your policies and procedures and dusting them off and talking about them sends a strong message to your leaders and to your employees that you care about this issue, and that you are going to take steps, positive steps, to make sure that your workplace is free from harassment, and you're going to resolve problems as they arise. So, it's an issue I would say don't be afraid of. Everyone's talking about it. The fact that you talk about it or not talk about it sends a strong message. Let me show you some numbers from the hospitality industry, or women's sexual harassment in general first. But remember that it was October of 2017 that the New York Times article was written about, or New York Magazine issue was written about Harvey Weinstein. It seems like it was an awful long time ago, but we are creeping up on a year in a couple of months. So I picked a survey that you can see on this screen for a reason. It was before Harvey Weinstein. The 2015 survey of over 2,200 female employees surveyed, 1 in 3 answered the question, yes, they had experienced sexual harassment at work. Now, I don't mean to exclude men in this discussion, but I will tell you, having looked at this issue pretty thoroughly, it's difficult to find surveys of men and of male employees harassed. That's not that it doesn't happen. It certainly does. Men get harassed, women get harassed by women, men get harassed by men. But predominantly the complaints are female employees complaining about men. And so many of the surveys and a lot of what you'll see here today sort of refers to females complaining. But 1 in 3, 33% had experienced sexual harassment at work. 16% of the women who said they had not experienced sexual harassment said they had experienced other sexually explicit behavior or remarks that they didn't consider to be harassment. That's a lot of folks. That's a lot of women reporting harassment. The highest of any field, 42%, is in the food service and hospitality industry. That should get our attention in this industry. Now, I'll tell you in a moment why and why some of the government agencies think that we have a particular problem in this industry, but the numbers certainly support that, that the industry does have some problems. And so, again, before Harvey Weinstein, the unions have gotten involved. Chicago's Unite Here Local 1 union started a hands-off, it's a hospitality union for those of you not in the Chicago area, a hands-off, pants-on campaign, surveyed 500 female hotel and casino workers. 58% of hotel workers and 77% of casino workers reported they had been sexually harassed by a guest. That's part of what makes the industry particularly vulnerable. Most employers have to worry about their employees being harassed by another employee or perhaps a manager. In this industry, we have to worry about that as well as employees being harassed by third parties, by your guests, who are sometimes not particularly well behaved. Only 33% of those reporting that they had been sexually harassed reported the harassment to a supervisor. 43 said they knew someone who reported and nothing had happened, or they thought nothing had happened. And only 19% had said they'd received training from their employer on how to deal with sexual harassment by guests. Let's pause there for a minute. There are a lot of employees in this industry that have unsupervised access with your guests, or your guests have unsupervised access to them. And so when I ask you to sort of stand back and think, how do I train my employees to deal with an unruly or misbehaving guest? The spa industry, the spa departments in most large operations have dealt with this pretty effectively. We give those employees specific instructions on what to do and what to say if a guest or a customer does something inappropriate. But we don't necessarily do that with our other vulnerable employees. I asked the hospitality group recently to raise their hand and tell me who they thought their vulnerable employees were to guest harassment. They raised their hand, and the first one said front desk. And I said, well, let me pause there for a minute. Your front desk employees might have to deal with misbehaving guests and unhappy guests, but unlike your housekeepers, your room service attendants, your bartenders, your servers, they're not really dealing with guests in private areas where bad things can happen. So I urge them to sort of think outside the box on that, not just bad behaving guests, but where potential harassment can occur. And as you can see, only 38% said they felt satisfied with their employer's response. The same survey, the Hands Off, Pants On campaign also reported some pretty concerning behavior. I'm sorry, that was my fault. Fairly concerning behavior. I mean, look at the kind of stuff that female employees were reporting. Employees in other industries don't have to deal with a guest showing up naked when they answer the door, or exposing themselves, or those kinds of behaviors. So, again, I urge you to think about your vulnerable employees. And it's not just the unions, and it's not just the Huffington Post. The government agencies believe the industry has serious harassment problems as well. In 2017, 5,400 sexual harassment complaints were filed by women with the Equal Employment Opportunity Commission, and that's the federal agency that doesn't even take state complaints into account. 12.5% came from the hotel and food service industry, once again, more than any other category. And the agency that looks at discrimination harassment complaints, the Equal Employment Opportunity Commission, says, here's why. Here's why we think it. We think the industry employs a large number of what they consider to be vulnerable employees. Foreign workers considered vulnerable. According to the National Restaurant Association, nearly 25% of restaurant employees are foreign-born, versus the 19% for the overall economy. And so foreign workers and young workers are maybe hesitant to complain when something occurs. They may have questionable immigration status, so they're hesitant to get involved with any kind of government agency. Young employees don't know their rights, don't understand their rights, don't understand the way the workplace should be, may participate in some of this behavior and not realize the potential consequences of it. So it's important to identify your own vulnerable employees in this area. Like a good government agency, the EEOC says we're going to have to look at this issue a little closer, and they put a task force together. And I put in quotes here in the first bullet that the EEOC said, and that's their phrase, a jaw-dropping moment. 30 years of corporate training has had little effect on preventing workplace harassment. The numbers just have not gone down. They haven't gone up, but they haven't gone down. 90,000 plus charges filed at the federal level. Again, 1/3 relate to harassment. And the EEOC thinks 90% of harassment victims never file a legal complaint. Now, I don't know how to test that 90% number, but I think it's logical to assume that some harassment victims, probably a large number of harassment victims, never actually file a legal complaint. They may complain internally. They may complain to no one. They may complain to no one but their friends or their coworkers. I always remind people that work in the industry that your employees, especially your good employees, don't like to complain. Your good employees, your best employees, are collaborative, and they want to talk to you, and they're open, and they communicate well with you. And they don't want to be a complainer. And I also say think logically. If let's say a young woman is a hostess in a restaurant and she's being harassed by someone, a chef or a guest or a server, what is the likelihood that she's going to file a formal complaint under your harassment policy? Pretty small. And what's the possibility she's going to go to her manager and file a formal complaint? Unlikely. What she's going to do is going to complain to her friends and say, you know, can you believe that creep said this, or so-and-so did this? I mean, that's the likely way a word is going to get out about a potential problem. So be open to that, and provide some extra time and guidance and attention to employees who may be particularly vulnerable. I mean, the numbers are real here. The EEOC recovered $165 million for workers alleging harassment. Those do not include private lawsuits. That was just the agency's ability to collect in terms of settlements or mediations, money for workers alleging harassment. The task force had some pretty key findings here. They said leadership and accountability are crucial. If you're going to do training, holding frontline and mid-level managers responsible for reporting harassment and preventing it, you need to do training. I know we've just said the training has not been particularly effective, but that's not that we should stop. What we need to do is think about training in a different way. We need to stop talking about liability and how to use the procedure. I think we have to be very practical about how to train our leaders and what they should and should not say, and when they should and should not go get some help from HR or higher up leadership. So I think our training has to change. Your leadership needs to be engaged. It always saddens me when I do harassment training and the general manager doesn't attend or the CEO doesn't attend. I think it's important to send that message. So review your policies and procedures. Again, dust them off. Make sure that you've got a healthy reporting procedure. I say multifaceted. In other words, give a potential harassment victim a couple of avenues to complain. If he or she is uncomfortable reporting it to their supervisor, make sure they can go directly to HR or to the general manager. Make sure there's an anti-retaliation provision in there. The number one complaint filed at the EEOC at the federal level is retaliation. If a lawyer can't prove their client's been sexually harassed, they'll prove she was retaliated against for complaining about it. It's a lot easier to prove that. So be careful. And then periodically test the reporting system or meet with your HR team and ask them the last time they got a complaint, what did it look like? How did we handle it? Who responded? Who investigated? And what was the resolution? So let's change our focus on training. And the EEOC is going to continue to be very active here. They're launching, they'll change the name, but something like the It's On Us campaign that we saw with campuses trying to reduce sexual violence. And they're going to do some outreach on their website and elsewhere to young people at work. And so we as an industry need to pay attention to that as well. There's some other proposed responses. This is, as you know, a wide variety of attention. The Restaurant Opportunity Center United basically says the tipped minimum wage is the primary driver of sexual harassment. Agree or disagree, it is certainly a serious advocating point for them, that it's keeping primarily women in low-wage jobs, that they don't feel they can leave even if they're being sexually harassed. The Hotel and Restaurant Employees Union is advocating for mandatory panic buttons for housekeepers. Those are mandatory in a couple of locations now, a couple of cities. Increased surveillance in your facilities, and the banning or blacklisting of guests who've sexually harassed employees. These are all difficult, they're costly, and they potentially pose some other liabilities as well. The states are getting involved, and the federal government. Under the tax reform law, you know, the federal government budgetary process is fascinating. They are often interesting things pop up in legislation that you weren't expecting had anything to do with tax reform. But they have this most recent tax reform law prohibits a tax deduction for any sexual harassment settlement that contains a confidentiality provision or a non-disclosure agreement, and a bill has been introduced in Congress to exclude sexual harassment and gender bias claims from arbitration agreements. Both of these measures, one passed and one pending, are designed to bring sexual harassment complaints and the settlements of them into the open. And the theory is if people are forced into private arbitration or are forced into a non-disclosure agreement and a settlement agreement, that other people will not realize that this is a bad work environment or that sexual harassment may be going on at a particular workplace. Some fairly high-profile cases brought this to the attention of Fox. Gretchen Carlson from Fox News testified before Congress on the bill that's pending as well. So there are some legislative responses, and the states are reacting as well. New York, I can't name them all, but New York has just passed a very comprehensive law that requires employers to adopt a written policy, requires annual training. That's already required in California for managers and employees, prohibits, just like I discussed, confidential settlements unless the complaining employee requests them, prohibits mandatory arbitration agreements covering sexual harassment, and very broadly extends coverage to non-employees. So a contractor, a vendor, a consultant can sue your company for sexual harassment without having to prove that they're an employee or a joint employee, like the law is in most other states. Washington State is doing something similar as well. They do allow confidentiality provisions in settlement agreements, but they're prohibiting non-disclosure and waiver or other documents, preventing employees from discussing sexual harassment. So the states are moving forward. Again, before I leave this topic, I would urge you as operators and owners to take some time. This is an issue that is worthy of some discussion with your leadership team. And again, maybe dust off your policies and procedures, and make sure you're complying with sort of modern day standards in this area. Another topic that generates a lot of discussion when I talk to a live audience, and perhaps with you all as well, is the issue of gender identity discrimination. Many workplaces, not a significant issue. Sometimes someone that's transitioning in their gender will cause some chatter or make people uncomfortable, or they're not using the proper pronouns. But oftentimes in the hospitality industry, we get some added issues. We have the use of restrooms, we have the use of locker rooms, and we have uniform standards. So the EEOC, again, the Equal Employment Opportunity Commission, and several federal courts, more and more as we move forward, are taking the position that discrimination against a transgender or transitioning individual is discrimination on the basis of sex. Now remember, Title VII was passed in 1964, and it prohibits discrimination based upon sex. I'm fairly certain that the drafters of that law likely were not thinking about transgender employees. And the law is not written that way. But it's just written broadly as sex. And so, but the enforcement agencies, obviously some of the federal courts have said, we consider it gender discrimination if you discriminate against someone based upon their transgender status. Just this morning, I read an article by someone who is suing, a male transitioning to female is suing Starbucks in California for discrimination based upon her transitioning status. And the article really focused on, of all companies, this sort of welcoming and open and very forward-thinking company, Starbucks, had an individual manager who had religious beliefs that conflicted with this employee situation. And so, again, the conservative employer, who doesn't really want to be the Supreme Court test case on this, which I presume is most of you, will modify your policies to include gender identity and transgender employees, your discrimination and harassment policies, and consider accommodating transgender employees. And that means restrooms, locker rooms, and appearance policies. Generally, let me say, I'll ask the question that you would likely ask if you were in my audience, and that is, what about other employees' privacy rights? If I have to let a transitioning employee who's a male transitioning to female, but he's still a male, use the women's locker room or use the women's restroom, what about the privacy rights of other employees? It's a legitimate question, and it's fair. But I will tell you that the courts and the agencies that are enforcing these laws say this employee needs to live their life as the other gender before they can have the surgery, and so that's a long period of time, and that if somebody's uncomfortable with that employee using that restroom, they can go use another private restroom or a gender-neutral restroom, but you can't make the transitioning employee do that because it's not consistent with the transition for them. So I urge you to educate your leadership about this issue and to make sure that they understand that we need to deal with these issues sensitively and respectfully and confidentially, regardless of their personal beliefs about this, because this issue certainly does generate a lot of discussion, and people have some pretty strong feelings about it. In case you're wondering, 1.4 million Americans identify as transgender, according to a 2016 study out of the UCLA School of Law. If you're wondering which states have the most folks identifying as transgender, number 1 is Hawaii, number 2 is California, number 3 is New Mexico, and number 4 is Georgia, where I sit today. The lowest I go, I know you're not surprised, North Dakota, Wyoming, and Iowa. I don't know where all the others fall in as well, but you can look at the study if you want to see where your state may fall in. So, again, before I leave this issue, transgender employees, we're hearing more and more about it. We're certainly just trying to make sure your leadership is aware that if it's raised in their department, they need to reach out to senior leadership, reach out to HR right away, and figure out how we're, as an organization, going to deal with what can be a very uncomfortable situation. So we go from sex to drugs. No surprise to you all, I'm sure, that we're talking about marijuana and that we're still talking about marijuana. Just so you can study this map at your convenience to look at the marijuana legislation status around the country, I probably need to update this every couple of months because it is a constantly moving map. What I will tell you is in every single state that has passed a marijuana law, it does not preempt the federal law. Marijuana is still a Schedule I drug under the Federal Controlled Substance Act. Schedule I is the highest level. Being on Schedule I means the feds think it's a high potential for abuse. There's no currently accepted medical use in the U.S., and there's lack of accepted safety for the use of it. That is the federal position. And so what are the feds doing about the various states that have passed legalized marijuana, either medicinal or recreational? Under President Obama's Department of Justice, they declared that enforcement of marijuana under the federal law with respect to state laws was not a priority, and they did not prosecute a single case. Under President Trump's Department of Justice, Attorney General Sessions declared that the state should expect greater enforcement of federal laws regarding marijuana, although anecdotally we're not necessarily seeing that. So we ought to continue to pay attention. If you happen to be in a state that has legalized marijuana, please educate yourself about the way your state is viewing this. The courts have been a little bit all over the place. California's got legalized marijuana, but in 2008, California's highest court they have not changed this opinion yet, that it only protects you from criminal prosecution, and if you fail a pre-employment drug test, your employer has a right to terminate you or have a zero-tolerance policy. And that's in California, which is always where I expect the most liberal of policies. Oregon has said the same thing. An employer should not be forced to accommodate use of an illegal drug, even though it's legal in the state. And the state of Washington as well. Again, two very relatively liberal states have found it in favor of employers on the issue. Montana and Colorado have had similar issues. Colorado has a bit of a twist because Colorado has a state law that says you can't discriminate against someone based upon their legal activity off premises, which would include marijuana use. And so the Colorado Supreme Court again found in favor of employers, just like Montana. New Mexico. Right? New Mexico, same thing. So as you can see, I'm sort of just scrolling through a few of these. And again, we know it's never really quite that simple. Massachusetts just threw sort of a wrench into this. So in July of 2017, the highest court in Massachusetts indicated the decision that a handicapped employer, disabled employee with a need to use medical marijuana may need to be accommodated under the state's handicap discrimination law. So again, it's important that you know what your state requires and the current position before you, as you look at what your drug and alcohol policies are going to look like. I will tell you, I have a number of clients in the industry, especially in states where marijuana has been legalized, who have for practical reasons have decided to stop pre-employment drug testing. And the reason they've done it is because their applicants don't realize that they're going to drug test, and since the pot is legal in that state, they think there's no harm, no foul, and they're having too few applicants able to pass drug tests. Even those employers who are foregoing pre-employment testing for marijuana have retained the right to test for reasonable suspicion or post-accident in certain circumstances. So it would be wise, if you're going to roll back some of your drug testing in this area, to make sure that your folks, especially in safety-sensitive positions, are subject to testing, under certain circumstances, like reasonable suspicion. So from drugs to pregnancy. The Pregnancy Discrimination Act has been in place since in the 1970s. And it simply says, it's a non-discrimination law. Unlike the Americans with Disabilities Act, which requires accommodation, this law simply says you may not discriminate against pregnant employees. You must treat pregnant employees the same or similarly to, or no worse, than employees who are not pregnant. Male, female, it doesn't matter. Non-pregnant employees. And for many, many years, that's really all as employers and defense attorneys we had to deal with. Very recently, the EEOC, again, has taken the enforcement position that the Pregnancy Discrimination Act, in addition to non-discrimination, requires accommodation of pregnant employees. Now, it's not written in the law anywhere. And again, if you want to be the test case that goes to the Supreme Court, UPS tried it already and then backed off, but call me up. I'm happy to Supreme Court cases are super awesome, and we're happy to help you. But you probably don't want to take on a multi-million-dollar case. And so most employers that I work with are taking the conservative position, and that is we are going to accommodate our pregnant employees. We're going to include those folks like we do an employee with a disability or with a religious accommodation need who comes forward and says, my doctor says I need X, Y, and Z during my pregnancy or right after my pregnancy. Engage in the interactive process to determine whether a reasonable accommodation can be given to that employee unless there's an undue hardship, just like we do with an employee asking for an accommodation for disability. So I think it's important that you, again, on the conservative side, that you build into your handbook. I would urge you to consider an accommodation policy where you direct employees where to go if they need to ask for an accommodation for religion, for disability, and add pregnancy to that list. I find many in the industry already accommodate pregnant employees, especially in certain departments like housekeeping, because we need to retain employees. And we have so many women that work in those departments, we'd quickly run out of folks to work. So we're already likely in the industry doing it on an informal basis. So I think it's important just to formalize that process and to be prepared to respond to a legal challenge by showing what your policy is and the procedure. The states have started to step in. Even though the federal law doesn't make it clear, the states have stepped in, and 22 states in the District of Columbia have passed laws requiring accommodation of pregnant employees. 18 of those passed since 2013, all with bipartisan support and mostly unanimously. So, the core principles in these laws are a pregnant employee with a medical condition shouldn't be forced out on leave or terminated. They should be accommodated. Some of the details differ, and in some states there's required language in your handbook for pregnancy accommodation policy. So be cautious about that and make sure you know if you're in one of those states. Here's a list briefly, but fairly easy to find out if your state's covered and what your state law may say. But I urge you to take a look at that. This is an active area in terms of legal complaints. So another trend that we're seeing is paid sick leave. The federal law is limited to unpaid leave under the FMLA. There is no federal paid sick leave law, although the president's daughter has been pushing this issue and has been advocating for paid sick leave. So currently, if you have 50 or more employees, that work within a 75-mile radius of each other, and that could mean several different properties depending on how you run your ownership and how you manage your properties. They could be combined for purposes of FMLA coverage. You are limited to allowing employees to take up to 12 weeks of unpaid leave for their sick time, a serious health condition of a family member, for the birth of a child, a handful of reasons. So the state laws are trying to fill in the gap, and what they're doing is requiring paid leave, mostly on an accrual basis. And what I would urge you to do is that, I listed some of the issues here, and I will show you the states in the next slide who have passed them, but what you need to look at is who's covered, which employees, is it full-time and part-time employees, or just full-time employees, and what must be provided, and for whom may sick leave be taken. Sometimes it goes beyond just the employee's sick leave and goes to family members. For what purposes may the leave be taken? Sometimes it's a doctor's appointment. Sometimes it has to be more severe sicknesses. There are certain processes that you can require your employee to follow that must be stated in your policy. Is there a waiting time period upon hire? Is there a accrual? Some states have sick time is accrued, but they're not permitted to take it until after 90 days. And a very burdensome provision in many of these state laws is the requirement that you allow employees to roll over their sick leave from year to year. What I'd also urge you to look at here, if you haven't looked at, I'll show you the states right now. If you're in one of these states, it's time to seek some help. Most of the time, if you are already offering employees paid time off, and either as a PTO policy or a vacation policy, you can combine that into your sick leave policy. You don't necessarily have to give additional sick leave. You do, however, have to modify your existing policies to make sure that you are covering some of the issues that I mentioned in the earlier slide. Who's covered and how does it accrue, and are they accruing enough? If you're in these states, and I expect that this list will expand as well. It has been, it's a hot topic, and if they don't do it at the federal level, the only way to get this done is at the state level. And if that wasn't enough, there's several cities, as you can see on my slide, that have mandated sick leave laws, and I haven't included all of them. I just, on this slide, included those that are in states with the most city-mandated sick leave laws. So California, New Jersey, Washington, and a handful of others. So if you're in any of these locations, or certainly it's time to take a quick look to see whether you need to have a sick leave policy in place or combine your sick leave requirements with your PTO policy. On to arbitration. The federal courts are overwhelmed, and most employment disputes, except for a handful of states, California, for example, has a significant number of state law legal challenges for employment law. But in most of the rest of the country, employment actions show up in federal court. And many years ago, the Supreme Court said, we encourage private arbitration. The federal courts are jammed full, and we can't handle the backload. For those of you that haven't, and I don't wish this upon any of you, but if you've had an employment-related lawsuit that goes to trial, for example, you should expect 2 to 3, if not 4 years of the litigation process. And this is a very slow process. And so the courts are happy for private arbitration agreements, and the Supreme Court in the AT&T Mobility versus Concepcion case said we absolutely will ensure that arbitration agreements are enforceable. So policy certainly favoring arbitration of employment disputes. And then under the Obama administration, the National Labor Relations Board issued a decision that stated in the D.R. Horton case that an employer violated an employee's Section 7 rights, their right to join and form group action, unions and group action. Requiring mandatory arbitration for class and collective actions was a violation of their Section 7 rights. This was problematic because around the country, courts issued various decisions, and depending on what your arbitration agreement said, you could force arbitration for individual disputes. So an individual claiming wrongful discharge, an individual claiming race discrimination or gender discrimination or age discrimination, but you couldn't force arbitration of their wage and hour claim because they had a right to join in a collective action. Well, those are expensive, and employers wanted those covered as well. And so in a very important decision in the Epic Systems Corporation, we called it an epic win. In May of this year, the Supreme Court overruled the National Labor Relations Board and said simply the right to bring a collective, a class-based claim is not considered concerted action, can be included in an arbitration agreement. So from a practical standpoint, if you have arbitration agreements with your employees, take a look at them. Let's make sure it's as comprehensive as it needs to be. If you don't have arbitration agreement in place, at least consider it. Seek legal counsel and talk through the pros and cons. They're not all pros, but they usually outweigh the cons. What I do want you to also concern yourself with are some of the practical considerations. If you have current arbitration agreements in place with your employees that exclude this class collective waiver that we want in agreements now, what are you going to do? You're going to put new agreements in front of employees? Some states say that's okay, and you can require employees to sign it to continue to work for you. Other states say you have to give them additional consideration, a $100 bonus, an additional PTO day, or some other benefit in exchange for signing the agreement. And what are you going to do if an employee says, I don't want to sign this, I just want my old agreement in place. I've already signed one, I don't need it. So there's some practical considerations to rolling out either a new arbitration agreement or to replace existing ones. And so, sometimes employers will say, as you can see in my second bullet here, maybe you just leave the existing employees' arbitration agreements in place and you just roll out a new arbitration agreement for new employees. Lots of things to consider, but I do, before I leave this topic, want to urge you that this is such a win for employers that do want to have arbitration agreements that it really behooves you to make sure you're taking full advantage of the arbitration agreements that you may have in place. So from arbitration to criminal background checks. As I'm sure many of you have seen, there's a nationwide movement. Right now, 29 states and the District of Columbia and over 150 cities and counties have adopted some form of ban-the-box or fair chance laws. These laws are designed to prohibit you as an employer from asking about criminal convictions on your application. Now, they vary widely, and they vary widely in this sense. Some of them allow you to ask in the first interview. Some allow you to only ask after you've made an offer of employment. So there's, a lot of bells and whistles that come along with these, but the broad brush issue here for the hospitality industry is you have a lot of employees who have access to unsupervised access to your guests, to your money, to your guests' money, to significant amounts of property and alcohol and assets. And if you can't ask on your application, and you only get to ask as you move down the road in the employment process, and somebody's convicted of a significant criminal offense that you would never have considered them had you known at the time of their application, you spend a lot of time, effort, and resources to move somebody through this application process only to withdraw their offer. So it is a burden to you. And so in addition to these ban-the-box laws, the EEOC has gotten in on it as well and said you cannot have across-the-board policy that says we will not hire an employee with a felony conviction or any kind of conviction. Their theory is that if you have a no-conviction policy, you will systematically discriminate against minorities because minorities are more likely to be convicted than non-minorities. And you certainly can't take just arrests into consideration because minorities are more likely to be arrested than non-minorities. Agree or disagree with their theory, they have some statistical information that supports their theory, and they said you cannot automatically deny employment based upon criminal convictions. You must have a policy that examines each candidate on a case-by-case basis. So whether you can ask early in the process or late in the process, once you ask, you still must make a decision based upon job relatedness and consistent with business necessity. I would urge you in this industry to not forego asking about criminal background of your applicants at some stage in the application process. I think it's important that you know this. And whether it's you can ask it early or you have to ask it late and terminate an employee, the harm an individual can do in your workplace may significantly outweigh the burden of gathering this information. I had a client recently contact me, and they said they'd hired an individual that had just gotten out of prison. They didn't know it at the time, but he'd gotten out of prison, and they asked him when they put him on the payroll before his criminal background check came back, which is a bit of a flaw in the system, but I understand it happens. And his conviction came back as a murder conviction. And when they asked him about it, he said vaguely something, it was a bar fight, and he killed a guy, and it was self-defense, and he did 15 years. And so the client called me, and we were talking it through, and I said, well, number one, he's already lied to you. Self-defense is a complete defense. If you killed somebody in self-defense, you don't go to jail at all. So if something else happened, we can count on that. And I said, well, what's he doing? He's a public housekeeping attendant. He's working out in public areas. And they said, we decided to keep him. He seemed to be a good guy, and we decided to keep him. I said, well, okay. Why are you calling me? And they said, well, he's been missing. He hasn't come to work for 3 days. And we heard that there's a warrant out for his arrest for some sort of violent incident in his neighborhood. And I just sort of was quiet on the other end of the phone, and they said, we're just wondering, can we terminate him since he hasn't shown up for work for 2 or 3 days? And my answer to them was probably a little sarcastic. I said, he's not coming back to work. You can go ahead and process his separation. He's not going to come back to work. But I think it just really showed me so many flaws in the system. Some background checks take quite a while to come back, and so you move forward with a hire, and then now you're in a position of having to potentially terminate somebody who has a very serious conviction. So be cautious of that. Please don't have a across-the-board no felony conviction policy. Have somebody within your organization and your hiring process, in HR or otherwise, that is responsible for looking at the background check and making the decision to either hire somebody with a criminal background check and why you hire them, why you're willing to hire them, or make them accountable for the decision not to hire someone. Because if you get challenged, we want to be able to say, here's why. This was the position we were hiring them for. It's a position of trust, or has access to children, or whatever it may be. We want to be able to articulate why you didn't hire somebody based upon their criminal conviction. For those of you that are wondering what happened to the Department of Labor's overtime rule that raised the salary level, or proposed to raise the salary level for exempt employees, non-overtime eligible employees, it is not gone. It is on the back burner, but I wanted to share with you where it is because it's going to come back in some form. Just a reminder, under the final rule proposed by the Obama administration's Department of Labor, the annual salary threshold for an exempt position, if you're executives, your administrative employees, anybody you're treating as a salary-based employee, no overtime, doubled from $23,660 to $47,476 a year. It actually is a weekly salary amount, $900-something a week, but annualizes out to $47,000 plus a year. And you would not have been allowed. You're only allowed to use non-discretionary bonuses like commission-based pay or bonuses, incentive-based bonuses for 10% of that salary requirement for an employee to retain their exemption. This hit the hospitality industry very hard. It hit the retail industry very hard because if you think about, perhaps some managers in small properties or in small geographic locations, or assistant managers who are, sitting at a, $35,000 or $40,000 salary level, are not going to be considered exempt under that new number. And so that was very disturbing, and there was a court challenge, and really at the very last minute, the judge in Texas issued an injunction to stop the rule from going forward. And with the change in administration, the Trump administration stood down on this issue and regrouped. And what they have done is issued a RFI, which is a request for information, which they're required to do, basically seeking comments from the public. They issued it in July of last year. They asked a lot of questions about the salary level, the duties test, the cost of living adjustment. There was automatic cost of living adjustment, the inclusion of bonuses, automatic updating. They asked questions about how many people had made changes, getting ready for the old rule. And it's been sitting there for about a year. And so the request for information is closed, so no more comments are being accepted. And now we're waiting for the rule to be issued by the Department of Labor. The new Secretary of Labor has suggested publicly that a higher salary is probably in order, and $33,000 was a number that's been mentioned a few times. But keep this on your radar, because I think that inevitably we're going to have some change here, and that may require you to make some changes to the way you pay some folks. But it's not forgotten. It's maybe forgotten it now, but it's not gone. Pay equity issues. Everybody hears about the pay equity. Interestingly, we have a law on the books, and has been for a long time, that requires you to pay men and women for equal work, equal pay. But again, we see a lot of studies that indicate that working women working full time are paid at 80% or less of what men are paid, and some states have decided to step in and prohibit you as an employer from requesting salary history from an applicant on an application or at any time during the hiring process. It's an attempt to close these gender and racial pay gaps, and the theory is if, as a woman, you start out behind in pay and your future salaries are based on previous salaries, that it just compounds over a lifetime, and you remain behind your male counterparts or your non-minority counterparts. And so there are a number of states that have, and locations that have just simply banned any kind of salary history inquiries. So again, it's a little bit of a hard to see map here, but the green is showing you the locations who have currently issued bans on pay history, and we are expecting to see more. There are several states that are considering banning salary history inquiries right now. So, if this is in your, if you're one of these locations, or perhaps others, keep an eye on that and make sure we adjust our hiring procedures and our applications if they pass this in your jurisdiction. Let's talk about a couple of other things before I open it up for questions or let you go, and that is panic buttons and other security measures that are being pushed in the industry, and in several states and cities have passed this. So as you can see, New York City implemented panic buttons for housekeepers, and that was implemented through a citywide collective bargaining agreement. So it's not a state or city piece of legislation. In 2016, Seattle's ballot initiative was led by their local hotel union. It is probably the most comprehensive and burdensome of the panic button or security measure legislation that we've seen. Chicago, seeing that it was inevitable, worked with their city council to dial back some of the measures that were in the Seattle ballot initiative, and were able to pass one. It's passed and being implemented now. Chicago, at least the Hotel Association there, thinks it's a little bit more manageable than the Seattle one. We're waiting for an implementation date in Sacramento, passed by their Board of Supervisors. So the unions are pushing to incorporate these requirements in new contracts. Las Vegas, we just saw a significant push for panic buttons for housekeepers, room service attendants, engineers, anyone that may go into guest rooms in an unsupervised manner. So there are some issues here, and I urge you to stay in touch with your state hotel associations who are on top of this issue. There is a significant cost to this. There are, a wide variety of versions of this panic button, simply from a necklace lanyard around your neck to a GPS tracking devices on people's phones. Those are some a wide range of, and if you at the trade shows, you should expect to see these folks out there. Some implementation challenges. The cities who have already tried to implement this, there's technological challenges. There's some logistics, training people how to use it, and then of course you're subject to the actual housekeeper, for example, maintaining it and keeping the batteries up to date and actually bringing it to work or checking it out of the location or not leaving it on their cart. And then, of course, some coverage issues. Housekeepers are at the top of the list here, but you've got room service attendants, engineering, bell staff, and a handful of other folks that go into guest rooms in an unsupervised way. And then, of course, liability. Who's going to, if it doesn't work or it's not used properly, if the housekeeper doesn't, isn't fully trained and it doesn't operate it exactly, what kind of liability or what kind of potential insurance coverage can you have for it? So keep your eye on that. That's been happening not at a federal level, but certainly at a state and a local and a city level as well. And so I think that I'm sure there are lots of other issues out there, especially in some of your locations. But I tried to give you an overview of what the industry seems to be, some of the hot topics, and what the industry seems to be talking about and some of their really significant challenges. So I urge you to, sit down with your leadership, take these slides and sort of go through whatever came to mind as we went through them. Sit down with the leadership at your properties and say, what are we doing in this area? What are we doing with what does our harassment policy look like? Does it need to be, updated and reviewed? Have we done some training on it recently? How do we feel about our hiring process? Do we have our arms around the various concerns, especially if you're in some of those states with ban-the-box legislation or salary history bans? It's time to do a little bit of a checkup here and there, and I'm hoping that the session was able to give you a handful of areas where you can focus your checkup.
Andrea, that was excellent information. Yes, thank you so much. You just covered so many important issues facing our hospitality owners and operators nationwide, and we're just so grateful that you were with us and that you did share all of this. So hopefully, those attending today will definitely be following up and reaching out for more clarification on specific issues they're facing. But thank you so much for being here today.
Thank you, Jennifer. I appreciate it. You all can see my contact information. I live and base here in Atlanta, but I do work in the industry all over the country, and so have a pretty good feel of how we can help. And again, compliance through prevention is really what we're looking for here. So please reach out if there's anything you think we can help you with.
Definitely. Well, thanks again. And I do have a couple of quick reminders for the attendees today. Just if you would please take a moment to let us know how you enjoyed the webcast today. You can do that by clicking the Rate This button at the bottom of the webcast player. Also, visit the Attachments tab where you can view some of the hotel investments that we have downloaded for you. Also, we have this webcast and our previous Hotel Investor Marketplace webcasts are available for on-demand viewing at our website, hbihotels.com. Also, our hotel brokers, our HBI hotel brokers, look forward to seeing you at many of our upcoming industry events. You can watch the hbihotels.com website to learn which events our brokers will be attending, should you like to schedule a time to meet with them. Two of our upcoming events are on your viewer right now. They're the Best Western International Convention and Trade Show. That's taking place at the Gaylord Texas Resort in Grapevine, Texas, September 30th to October 3rd. We also will be attending the Red Lion Hotel Corporation Brand Conference and Trade Show at the Mirage Hotel and Casino in Las Vegas, and that is December 10th through the 12th. So again, we would just like to thank everyone for attending today's webcast, and we hope you have a wonderful day.